Hello everyone, I'm Nagarathna and you're watching LiveLaw. We all are acquainted with the case of Bilkis Bano, a gang rape victim during the infamous Gujarat riots. Bano had approached the Supreme Court challenging the decision of the Gujarat government to allow the premature release of convicts who were sentenced to life for gang rapes and murders during the 2002 Gujarat riots. The matter was posted for final hearing yesterday by a bench comprising Justices K.M. Joseph and B.V. Nagarathna, but no effective hearing happened. The reason behind it was that some convicts objected to the affidavit filed on behalf of Bano, seeking to declare that the notices were served, saying that some respondents had refused notice. They argued that her claims were false, and the reason the service of notice was not completed was because the parties were out of station. The lawyers also claimed that Bilkis Bano played fraud and there should be criminal action against her. But her counsel Shobha Gupta denied these allegations and said that the affidavit was filed on the basis of postal endorsements. And because of these objections, the bench had to adjourn the hearing in order to give time to the convicts' advocates to file a counter affidavit to bring on record their objections. Moreover, the service was not complete with respect to all respondents, and as such, the bench directed that the service be completed for all the respondents through the concerned police stations. The interesting twist is that Justice Joseph is retiring on June 16, and considering it, he offered to sit during the vacation to hear the matter. The petitioners were satisfied with the suggestion, but the Solicitor General Tushar Mehta and the respondents' lawyers were not willing for the same. Finally, the bench decided to adjourn the hearing till July and to list the case after 2 weeks to see if the service has been completed. During all this, there were questions posed at the counsels regarding the way this case was being dealt with. To begin with, the counsels for the convicts strongly objected to letting the counsel for the petitioners begin their submissions. They said that they had not been given adequate time to file their responses. They also alleged that despite knowing the fact that 2 of the respondents were out of station, Bilkis Bano filed the affidavit saying that there was refusal on part of the respondents and that she played fraud with the court. The lawyer for Bilkis refused the allegations and said that notice was served through email as well to the advocates who were appearing for the convicts in the connected PILs. The bench asked the counsels questions like, was permission taken to serve notice through email to the petitioners? In answer to which, Advocate Shobha Gupta said that the court had granted permission for the same, but had also clarified that the respondents would have the discretion to accept notice served electronically. She said that only 2 of the lawyers responded, saying that they did not have instructions from their clients. Otherwise, everyone had filed responses in the connected matters. One more objection raised was that the envelope did not have the seal of the Supreme Court and hence the party could not be faulted for not accepting the notice. But Justice Nagarathna, after examining the postal records, found that this claim was false. The bench clarified that the matter would be taken up after 2 weeks only to a certain service of notice, and it would continue hearing it only after the vacations. Meanwhile, by reason of having to adjourn the hearing, Justice Joseph made a statement in open court that he understood this was a bold attempt to wait out the time he had left before retirement. He said, "It is clear what is being attempted here. I'll retire on June 16. Since that is during the vacation, my last working day is May 19. It is obvious you do not want this bench to hear the matter. But this is not fair to me. We had made it absolutely clear that the matter will be heard for disposal. You are officers of the court. Do not forget that rule. You may win a case or lose one, but do not forget your duty to this court." While Senior Advocate Indira Jaisingh told the court that the batch of petitions could be heard during the summer vacation, which Justice Joseph said he was prepared for, the Solicitor General Tushar Mehta, appearing for Union and State of Gujarat, and Senior Advocate Rishi Malhotra, appearing on behalf of one of the convicts, denied the offer and said that once an exception is made for one matter by conducting the hearing during vacations, soon the same will have to be done for many other cases as well. Besides this, one more significant development took place in the matter. Initially, the centre and the Gujarat government were reluctant to share information related to the remission of the 11 life convicts. However, yesterday the court was informed that they had agreed to place the original records before the Supreme Court of India. That's it about the video. We hope you like our content. If you do, please like and share. Also subscribe to LiveLaw and don't forget to press the bell icon for notifications. Thank you for watching.